Thank you for joining us today on The Best of the Best, brought to you by Biles Wilson, a boutique commercial litigation firm based here in the Dallas area, but we represent clients on a national basis. I'm Dunham Biles.
And I'm Jeremy Wilson.
And today we're fortunate enough to be joined by my good friend and world-class patent and intellectual property litigator and prosecutor extraordinaire. So please welcome our friend, Mark Nielsen. Mark, thank you.
Yeah, thank you.
Yeah, I appreciate you guys having me.
You bet.
So Mark, well, we usually like to start out with a little background about people, and I know a little bit about you, but you grew up in California, right?
I did.
So then how do you move from California to Texas?
Well, when I was a mid-teen, 15-ish, I was at one of those summer camps where you go away for a month, and our counselor there was from Texas, and he started talking about the University of Texas. It was not an expensive school for out-of-state tuition, and there were cute girls. So I'm like, and it was a good school. So I'm like, okay. And the next year, University of Texas in Austin was the #1 party school in Rolling Stone magazine. So that really got it on my radar screen. And when I applied to colleges, UT was the best school that I got into that I wanted to go to. And I went for my first 2 years of college and loved it, probably a little too much. And I transferred back to Southern California, but I've remained friends with some folks you actually know, Michael Francis, for all this time since the late 80s. And over the years, we'd come out and visit and always liked it here, wanted to move here, got admitted to the State Bar of Texas in 2008. And it took another 14 years to actually move for a variety of reasons. But in 2022, beginning of the year, we bailed on Southern California and moved to the great state of Texas.
So speaking of Michael Francis, USC, and University of Texas, I think there's a story there. So where was your loyalty when USC and Texas played for the national championship?
It was with USC, which is where I graduated. I was there at the game, and so was Michael Francis. And it was so amazing that you didn't even feel that bad when USC lost. It was just like one of those historic moments that it was great to be there.
Yeah. So USC, so that's a former Pac-12 school.
Yes.
But somehow you ended up at the institution known as the University of Washington. Just so everybody knows, I'm from Oregon. I'm a Ducks fan, so I'm not a huge fan of the Huskies. But Mark here, at least went to school there. So
I did.
So why Seattle? Why UW?
Well, when I was an undergrad at USC, those last few years of college, I got into working in research labs in biochemistry, neuroscience, and I was originally thinking I was going to go to medical school. But the research aspect of the lab work was so captivating to me that I decided I wanted to go to graduate school. And the sort of career idea was to ultimately have a research lab at a university and have graduate students and do research, biomedical research. And at the time, the professors at USC were like, you need to broaden your horizons. We tell everybody this. We will accept you if you don't get in anywhere else. And I applied to a variety of areas, and the Department of Pharmacology at the University of Washington is an outstanding department. So it wasn't somehow I was slumming, if you will, to go to UW. It was really a great choice. And I had a friend from my youth who was playing football at UW at the time. So I had a connection there, and the department was great. And that's how I wound up there in the summer of 1992.
That's interesting. I think a lot of lawyers, the kind of common joke is if I could have done the math, or would have gone to medical school, or would have taken maybe a route like that. What you were well on that path and leading down that road. What led you to shift gears at some point and switch to law as a profession?
There were two things. One, John Grisham was a very popular writer, and I was reading Grisham books in the mid-90s when I was in graduate school. But one of the major things that made me think about law was the O.J. Simpson trial.
Okay.
We were in our lab there at the University of Washington doing a lot of biochemical and molecular biological procedures. Molecular biology is basically, to put it in really blunt terms, it's playing around with DNA. And so when I saw the lawyers in the O.J. Simpson trial asking all those questions about blood biochemistry and the DNA evidence, I understood all of it. Mm-hmm. And I found it to be quite fascinating. And Dunham can attest to this, that I can be a little bit combative and argumentative from time to time. So I started asking around family and friends, do you think, law and lawyering might be a good fit? And everybody thought it would be a very good fit for my personality. And so I was far enough along in my PhD program where I didn't just hang it up and quit. I talked to my principal investigator, the guy whose lab I worked in, Professor Daniel R. Storm at the University of Washington. And I said, look, I'm going to go to law school. You need to help me finish up. Because you had to write a thesis, publish some papers. So for probably the last year I was there, I was really in high gear doing research writing. And he kept up his end of the bargain, and I went off to law school. Didn't really take much time off, and started in fall of '97 back in Los Angeles.
So, okay.
Oh, I know that. So I know for patent prosecution, you have to have a science background, and I want to talk with you a little bit about that in a minute. But I'm curious, at this point, when you decide to go to law school, did you know you would probably be leaning towards something in the intellectual property field or for patents, or did you anticipate using your science background the way you've ended up using it?
The way I've ended up using it, not necessarily. As I said, the O.J. Simpson trial, which was a criminal trial, was something that was very interesting. Scientific evidence was very new in the mid-90s. Yeah. Nobody was doing DNA stuff. And I wasn't necessarily looking to be a criminal lawyer, but it was that area of scientific evidence that was interesting. And after I took, criminal law or whatever the required class was my first year of law school, I kind of realized that was not the area I wanted to go into. And looking at intellectual property, summer clerkships and whatnot became more of a focus, and learning more about that. I think I took my first IP class in law school was trademark law, which I really enjoyed as well. So that became a pretty logical pathway to go on at that point.
Sure.
You actually stole my question.
But
so when you, as three of us know that most of the time what we really do is we read and write. And I happen to know you're a great writer, but was it a transition going from writing scientific based articles, medical articles, etc., and then trying to write IRAC and legal papers?
Not as much as you might think, because a lot of scientific writing is accumulating a lot of information and distilling it down and synthesizing it. Mm-hmm. So that I had become good at. And also, when you write scientific articles, typically your articles will have 4 sections: introduction, materials and methods, sort of data or outcomes, and then conclusions. And let's just say the introduction and conclusion are almost persuasive / semi-marketing based, because you want the people reviewing those papers to publish those papers. You want your results to be seen as groundbreaking, impressive, whatever it might be. And what's funny is I was one of my classes in graduate school is one of these grad seminar classes where we read scientific papers and talk about them. And one of the professors was a very well-established, very well-respected professor. He was older. At the time, he was probably 75 or 80. And he was known for sort of conking out in the back of the class. So we'd be talking about things, and young graduate students tend to read the marketing and the spin on the research and not necessarily focus in on the data. And you'd think Dr. Krebs was back there sleeping, and you'd say something, he'd be like, wait a second. What does the data say? And so I learned a valuable lesson, and it's very applicable to law. Forget about the spin that's put on arguments and things like that. What does the evidence say? What does the data say? And so in a lot of ways, the process of being very exacting, very precise, being able to synthesize large amounts of information was a very transferable skill.
Now, speaking of writing, did you ever get published along with a well-known person?
Yeah. Yeah. So the professor who used to conk out in the back of our class was Dr. Edwin G. Krebs. And not the Krebs cycle Krebs, a different Krebs, but he won the Nobel Prize in medicine with his colleague Edmund Fisher in 1992, which was my first year at graduate school. It was a big deal, parties all over the place. And when I was a rotation student, my first year of graduate school, figuring out which lab I was going to land in, I did some work, and Krebs was one of the professors whose lab was a part of the research. And so on the published research paper, my name is right next to Dr. Edwin G. Krebs. So my name is right next to a Nobel laureate on a published research paper, which is cool.
That is cool.
Yeah, absolutely. He was a super sweet guy,
Yeah.
not arrogant at all, very humble and genuine. So yeah,
That's awesome.
it is.
Well, maybe you could tell us a little bit about, for our audience, kind of, we've already said you do intellectual property law, but kind of in broad strokes, what that encompasses and what type of work you do.
Sure. Intellectual property is patents, trademarks, copyrights, and trade secrets. Those would be the four big umbrella categories. Patents relate to your inventions, R&D, things you invent, whether it's mechanical things, chemical things, electrical things. Software is a little bit harder to patent, but very, it's been patented a lot over the years. Things of that nature. Trademarks are your branding, your logos. I mean, you have Biles Wilson right here. You have a slogan, you have a logo. So those are trademarks.
Mm-hmm.
Coca-Cola is obviously a very valuable trademark.
And an even more valuable trade secret as the
and,
formula.
And trade secret for the formula, yes. Trade secrets, so kind of getting out of order, the trade secrets would be things like the formula for Coca-Cola, Google search algorithms, formula for WD-40, those are the KFC original recipe or trade secrets. And then where they're confidential and their value is that they're well-known, highly purchased, but because they're confidential and no one knows them, that's where their value lies. And then copyrights is creative. So artwork, literature, music, you can actually copyright software code. And so within those categories, trade secret's not a registration thing. It's a keep it confidential thing. Mm-hmm. But within the other categories, patents, trademarks, and copyrights, one side of what I do is to prosecute or register those rights for people. So filing applications for their inventions, their brands, their creative works, whatever that might entail. And, for patenting, I'm not necessarily agnostic as to industry because my knowledge only goes so far. Like electrical is not in my wheelhouse. Software to the detail you need to know is not really in my wheelhouse, but mechanical things, biological things of that nature, certainly I can write those. Trademarks, completely agnostic. It doesn't matter what it is. I can do that. Copyright's kind of the same thing. Although music copyrights are very unique and esoteric. And so I tread lightly. If things get too complicated, I will usually bring someone else in because music copyrights is its own kind of universe. There are different kinds of rights. Think about when you go to a movie and there's music that's part of the soundtrack. There are copyright rights related to the synchronization of the music with the motion picture. And a lot of the copyright law is so old and arcane that there's also what's called a mechanical right, which used to relate to sort of creating the phono record. There was a right to, like, however phono records were made, the right to actually lay down the music on that record. So it's very esoteric and can be very challenging, but by and large, you can register most things. I can do it. It's pretty easy and not very expensive. So I always encourage people to register your trademarks, register your copyrights. It's not that expensive. And as long as you're using the trademarks, they last. And copyrights last for your entire life plus 70 years. Mm-hmm. So it's meant to go on to your next of kin. And so that's good fun. And in terms of litigation, I litigate in all those areas. Certainly, I'd say over my career, patent, trademark, and copyright's been pretty equivalent. Sometimes some go up or down at various times, depending on the caseload. And trade secrets, I haven't done as much litigation on, but I certainly could if I needed to.
So then, given the nature of your practice, which is almost exclusively federal court, I assume.
Yes.
Does that mean that you're able to and do practice across the country, or are you particularly practice in Texas and California?
I would say historically, my practice has been, I wouldn't even say mostly California. It was a lot, but I've practiced all over the country, different federal courts, Texas, California, had a lot of patent litigation in Virginia, Michigan, Washington State. So it's kind of been all over. And, I'm admitted to a number of federal courts. And if not, you just get, kind of pulled in by your local counsel. So that's been fun. And the great thing, it's interesting to talk to people who mainly litigate in state court. Mm-hmm. They are terrified of federal court. Yeah. They don't like federal court. And I'm like, time out. Mm-hmm. You've got 83 rules that more or less work in every federal court in the country. Exactly. It's actually easier.
Yep.
Federal court judges can be challenging because they're appointed for life, and the only way to remove them is by impeachment. But so they can, some very few actually are what you might say dictatorial, but they have their rules. They have their ways they want to do things. And you either do it their way or you run into problems. So over the years, you've learned that there are judges that are more sticklers than others, and you just do it their way, and they're happy, and usually it turns out well.
Yeah, it's interesting you say that. I've always found federal practice to be a little more straightforward in that regard. There's predictability amongst the courts for the most part. Yeah. But, you mentioned copyright, and sometimes that can last like 70 years. I know years ago I would hear about every once in a while Congress kept extending that time period out, and it was called the Walt Disney Rule, I guess.
The Sonny Bono Copyright Extension Act.
Yeah. Do you think we're finally through that? I mean, we settled on 70 years or whatever it is, or is there still is there ever talk in the industry about that getting extended up?
I think it's probably a more or less dead issue at this point, because I think it was in the late 90s when the Mickey Mouse, sort of the original Walt Disney character imagery, was coming up for, their copyrights were going to expire. Disney obviously lobbied Congress, and it was literally called the Sonny Bono of Sonny and Cher fame. Mm-hmm. The Sonny Bono Copyright Term Extension Act, I think it was about 1998, and it added 20 more years. Mm-hmm. So it's life of the author plus 50 years, then life of the author plus 70. But that 70 expired several years ago. Mm-hmm. And I haven't heard of any major push to kick that out any further. I think they're looking at trademark rights, that images serve as trademarks as well. And as long as they're using them, they would continue to be protected in that way.
Let's see.
So I have a patent question for you,
Sure.
But I think it's probably not a fun question. It's probably a boring answer. But Jeremy and I once had a trade secret case, and it had some patent issues involved in it too. And one of the issues was that at that time the U.S. was first to invent, not first to file, and Japan was first to file.
Yes.
And so we had a problem. Our trade secrets were stolen, arguably, and by somebody from a Japanese company who then filed a patent application, and they were first to file in Japan. Yes. We by that point we had the patent rights in the U.S., but now we have a problem. When the U.S. changed the law to go to first to file, has that made any differences? Is it caused problems and made things better?
It changed the definition of prior art a little bit, and what prior art is the entire corpus of inventions and products and literature that's out there in the world that exists either prior to the time you file your patent application, or in the US, we still do have a grace period of 1 year. Like within your time you go public with something, you can file a patent application within 1 year. So it's shifted around the definition a little bit, but overall, I don't think it's had a huge impact in terms of, like in your situation, I'd probably have to know a few more details, but the idea that an application was filed maybe earlier in Japan versus earlier in the US, I mean, typically prior art is prior art, and it's generally a worldwide concept. And the America Invents Act passed I don't know, 14 years ago,
Mhm.
did clarify that certain prior art was intended to be worldwide, not just limited to the United States. So it may have impacted your situation, but I can't say for sure without more detail.
You mentioned software being difficult to patent a minute ago, and I was curious. You said sometimes it can get copyright protection. I guess that maybe is that kind of the backup if you can't. But before that, if you could talk a little bit, what is it about it that makes it more difficult to patent?
So there's a good story behind this. So when the internet was getting going in the sort of mid 90s, let's say, everybody was patenting their little pieces of code that were making the internet do a certain thing or making browsers operate in a certain way or act a certain way. And things that were more straight software were getting patented. And what was going on was, to be perfectly honest, the large tech companies started getting sued a lot. And a lot of those lawsuits were in the Eastern District of Texas. And they rightfully or wrongfully got very tired of getting sued on these little patents directed to these little pieces of software. And there were other ones that were obviously, I'm sure, were more elaborate, but they were getting sick of being sued. So they did what I would have done if I was advising them. They lobbied Congress. They lobbied the third branch of government through the courts. I'm sure they lobbied the executive somehow, some way. And the America Invents Act was a significant change to U.S. patent law that related to a number of things, but also the laws they were getting, the sort of common law through the courts. Software patents were being challenged under what's now called Alice. It's a Supreme Court case, or Section 101. Title 35 of the U.S. Code is where the patent laws are. And Section 101 used to be a very, loose filter, easy to pass, that essentially required an invention to have some utility. It used to be the utility requirement. Well, the big tech companies and others breathed a ton of life into Section 101, and there was an exception to patenting called abstract ideas under Section 101. It was a judicial exception, and that one in particular was used to say, oh, these software patents are just automating something that people used to do manually, and this is not really inventive. They're just giving the computer instructions and making the computer do what it normally does. There's nothing unusual or inventive here. And they were largely successful. So it became a lot harder, say, starting in about 2008, 2010, through Alice, which I believe was decided by the Supreme Court in 2014, to patent software. And there have been efforts with the first Trump administration within the patent office loosen some of the requirements so you could actually get a patent. The problem was the rules in federal courts remained the sort of law that was being generated by the Supreme Court and the Court of Appeals for the Federal Circuit, which handles all the patent appeals in the country. And that was the more stringent, less inventor-friendly law. So there became a divergence. And then in the Biden administration, it went back a little bit to they were a little more harmonized. And now the Trump administration, the acting director of the U.S. Patent and Trademark Office, Coke Morgan Stewart, has really started to try to curtail the rejections of patent applications and whatnot, and the challenges to patents because IP is valuable. Being able to patent and protect is valuable. And otherwise, what you're doing is you're taking all the R&D, all the development that's going on in our economy or in our business ecosystem and saying, yeah, it's not protectable. Anyone can use this.
Yeah.
And that's not cool.
Sure. No, although I guess there's tensions in that, like right, because the purpose is to spur innovation. And so you want to encourage people to develop things because they're going to get patent protection. But then if you're overly stringent, nobody else can do anything, right? And the internet can't grow. And so it sounds like there's maybe an overcorrection, and there's like a lot of things.
That's what licenses are for as well.
Yes, exactly.
Sure.
How many is it more?
And yeah.
Yeah.
But that's a fair point. And the other interesting thing, and these are conversations I have with clients a lot to try to explain to them why software is challenging to patent. I also say, look, the patent system is set up. Patents are very detailed documents. I mean, it is a lot of details, a lot of fine print, a lot of schematic diagrams. And the idea is that once a patent expires, and they only last approximately 17 years if you pay all your maintenance fees, once a patent expires, someone in that general industry should be able to pick that patent up and basically do what your patent was protecting. Mm-hmm. So you get this monopoly that's limited in time. And as you said, give some protection to spur the innovation, but it's limited in time. And that's how the system's supposed to work. Mm-hmm. But, on the software side, pivoting to the rest of your question from earlier, you've had to look at other ways to protect these inventions, and whether copywriting code is okay, but there's different ways you can write code to give the computer essentially the same instructions. So I don't think that's necessarily the way to go. People are using trade secrets a lot. They're they're using their trade secret protection to protect the functionality of a software program or an app. And sometimes if they're too simple, it's almost not going to matter. Anyone can reverse engineer it. But a lot of things do some pretty cool stuff, and trade secrets have been used. And now the new frontier really is AI.
Well, that's what I wanted to ask you, because you just said a little bit ago that talked about some of our IP laws are very old, and it's hard to make them work with how things have changed. So how is AI challenging our system and on intellectual property?
Very much so. I mean, so on the trade secret side, it is, unless, like OpenAI or Grok, those are trademarks, but that's not it. Being AI is no different. It doesn't impact trademarks. On the copyright side, again, if you have certain code, you could theoretically protect it, but I think the patent side is trying to adjust. And there's two sort of aspects of it. If you're developing AI algorithms, those might be patentable, particularly if they're very specific and they're causing computers to work in a way that they don't normally function. You're making the computer do something new and unique, and or do it in a new and unique way. And on the copyright side, super interesting, because people throw things into AI systems all the time. I've done this. I have a presentation coming up I think to the Frisco Visual Arts Guild on September 15th, up somewhere in like Hall Office Park or something. And I'm going to talk about AI and copyright, because there's going to be a lot of photographers there. Mm-hmm. And a couple of my visuals I'm going to use in that presentation, I took a copyrighted photograph, although it doesn't matter. And I ran it through a few iterations of ChatGPT and say, make this look like a Van Gogh, or make this look like, I think I used the word like a Flash Gordon, like the old Flash Gordon movie. And it came out with some pretty outlandish stuff. And people are like, oh, this is new and different and creative. I'm going to copyright it. Mm-hmm. Guess what? It's not copyrightable. You have to have human authorship. That's been litigated quite heavily. There's a couple people who are really pushing this on the patent and copyright side, mm-hmm. and human authorship is required. And if you're just putting it into an existing AI engine and giving it some basic instructions, that's not going to be copyrightable. If you're really being super specific, maybe.
Yeah, that's interesting. And I've also been interested on the AI copyright side. I think I saw the New York Times had sued maybe OpenAI a couple of years ago, and basically the AI at issue, I don't remember if it was OpenAI, had basically trained itself by reading the New York Times, reading lots of things on the internet, right? And it's always kind of interesting to me, because as a person could read all of that, right? And they've got that knowledge in their head. And if they opine based on that knowledge, they're not violating anybody's copyright. Yes. But, an AI sharing that information, doing it for commercial use. I mean, this isn't a free product. So it's like, there seems like there's a real kind of tension there where they're not, I don't think the AIs are saying, they're not reproducing the article for somebody and acting like the AI wrote it, but it learned from the copyrighted material. And I've always kind of found that fascinating issue. I don't know if there's been are you aware of that case, or are there any developments on that front?
Yes, that's a very hot area in the world of copyright litigation, and it's come up in music, it's come up with books,
Yeah.
come up with New York Times. And what generally happens is the copyright owners will sue, OpenAI or Microsoft, and say you are downloading copyrighted material onto your servers and training your system, having your system learn from our copyrighted material and for commercial purposes. And the question is that one download of material a copyright infringement? And courts are all over the map on this right now. Is it a fair use? Is it educational?
Yeah.
I think you could argue that both ways. There is a very interesting case. I believe it was out of the Delaware federal court where Thomson Reuters, who runs Westlaw, sued a company that was using Westlaw copyrighted material to train a different legal research engine that they were developing. And the court came out one way, and off the top of my head, I don't remember which side they came out, but the aggrieved party on that issue went to the judge and filed a motion for reconsideration, and the judge certified the issue to the Third Circuit. I think, and so that is I don't think the Third Circuit has ruled on that yet, but that is the situation, because clearly this new legal research app is going to be commercial.
Yep.
And they're taking copyrighted material, training their system on it, and they're going to be spitting out, AI generated information based on what is coming from copyrighted material. So I would say right now that issue is unresolved. I know there are courts, I believe the Northern District of California has landed on the side of the AI systems, that it's okay, it's a fair use, it's not copyright infringement. And on a similar but separate note, there is a divergence in the federal courts as to whether sort of having a copy of something reside on a server is a copyright infringement. This often comes up in the social media context where people are sort of reposting images maybe from Instagram, and there's things in Instagram's terms and conditions that would tend to allow that. But then when people see their photographs all over the place, they're like, hey, wait a second, I didn't allow that. And they have a thing called the server test, comes out of the Ninth Circuit, that comes out one way, and it's very, sort of pro social media company. And then there's other areas of the country that would be more pro artist or pro, copyright owner. And that's an issue that, at least in my mind, should make it to the Supreme Court before too long to be resolved, because there is a genuine dispute on how that works.
So all three of us are now in our 25th year of litigating.
Is that right?
Yeah, we're all 2000 grads.
Okay.
So I'm sure that there's some stories we can probably share. So can you tell us some great war story, or what was your favorite IP matter or invention, or what was some crazy one? Or
Yeah, I was wondering about a crazy one. So if I'll combine that
I think
question.
all of the above. I mean, when I was a brand new lawyer, I cut my teeth on a case where we were representing the son of a really famous photographer who took a lot of probably the best pictures of Marilyn Monroe. And we were having to navigate the differences between the 1909 Copyright Act and the 1976 Copyright Act. And the defense was throwing all kinds of stuff. So I learned on the fly, and, a lot about copyright law. And we had several cases. In the first case, the defense hired an expert, and this expert had a business where I guess he had, those sort of the photographic, sort of entertainment pictures that have the white border that says Marilyn Monroe, and it's got a little detail, it's got a picture. It's very much like a movie studio thing. Well, this guy got his hands on tons of stuff like that. And he submitted a declaration to the court basically saying, my business routinely lends licenses and, whatever. And it was a for-profit company. And it was a lot of the photographs that our clients had copyrights on. So we're like, okay, this guy just admitted
Yeah.
infringement in a declaration.
Yes.
We sued him the next day, and
Of course.
and so I worked on those cases. The first firm I was at for 3 full years, and right toward the end of my time at that firm, I bought my first. It was a condo in Southern California, and I had a housewarming party, and I had a tagline on the invitation: "The house that Maryland built." And so because they're working so hard on that.
That's funny.
Just lots of litigating, products that people know about. So I was involved in a dispute over it was a trade dress case, which is sort of the ornamental appearance of something being a source identifier, like the Coca-Cola bottle with the little grooves on the side, or the Rolls-Royce hood ornament. And this was the design of the bottle for sriracha sauce, the green cap. This was a company that was based in Southern California, kind of a rags to riches great story. Everybody loved sriracha, and it became a big industry. And some people were using green caps, and the bottle was very similarly shaped. And they didn't copy the trademark per se, but they copied the bottle design. And so we had a knockdown drag out. And I think my favorite part of that case was asking for when you're trying to chalk in a trademark case, you have to look at the similarity of the trademarks and the similarity of the goods, which are, kind of the key items. And I was looking for differences in the formulations of our client sriracha versus the Huy Fong, Huyfong was the main company that was a plaintiff there. And when I asked that question, they threw up a brick wall. We're not disclosing that. It's a trade secret, and so on and so forth. But that case eventually got resolved. So that was a fun one. Magic Bullet. You remember those little kitchen top blenders?
Yeah.
With the funny infomercial.
Yeah.
Making salsa and making margaritas or whatever. We had a patent infringement case related to the Magic Bullet for a while. So over the years, it's fun because when you can talk to people in a business networking context or clients, and you can say, I worked on X, and they can easily identify what the product is, it gives them a frame of reference. If I told them I was involved in a software case about a piece of code that instructed a browser to put thumbnail images of the homepage of websites alongside the search results, they'd be like, oh, what? Okay, whatever. I mean, you can kind of explain that, but when it's a tangible product that they're familiar with, it's a great point of reference. So, yeah. That's one of the great things about IP law, too. When IP is valuable, it's usually something most people know about.
Yes.
Sure.
Yeah.
Makes sense.
That's fun cases.
We're probably getting near the end of our time. So why don't you tell our audience, like, who would be a good client for you? Like who would need that type of person might need your service, and then how would they get in touch with you?
Sure. Thank you. I appreciate that. So I work with startups.
Okay.
So it's very important for startup companies to protect their intellectual capital and their branding. It creates value in the company. It can fuel investment in the company, and it allows them to carve out their little area and have some level of protection. So, and that's fairly industry agnostic, because I do have colleagues, even though I may not prosecute in a certain area, chemical engineering or software per se, I have colleagues who do. So it's something that, you bring in and you quarterback it with your colleagues, which is nice. And so startups is a good, I love working with startups. I've had startups build up their IP and then they sell, and I lose my job because the purchasing parties' lawyers are the ones who kind of take over from that point. I'm like, okay, I did my job even though I lost it. But, other established companies that are doing a lot of R&D, engineering, medical devices. Sometimes they're creating compositions to treat, certainly my wheelhouse would be biological conditions, maybe compositions to treat biological conditions, protocols. So many of the things most people in the world take some form of a drug, whether it's over the counter, prescribed, hopefully not illicit, but at some point, almost all of those things would have been patented because of the composition and, a method for treating some condition. And those are great. So, biological type companies, engineering companies doing a lot of R&D, almost any company really, to be honest with you, and other areas where patenting may not be on the radar, but branding may be very important. So I have clients in the restaurant industry where their brands and the names of their restaurants and their logos can be very important. Social media plays a huge part in the restaurant industry now, as you probably learned or learning with your burgeoning project. But Dunham, so protecting trademarks can be very important, and just consumer goods, I'll tell you a funny story. So about 20 years ago now, I get a call or an email from someone saying, "Hey, your cousin gave me your name." It was someone who tried to file their own, they did file their own trademark application and ran into more technical difficulties with the application process and ultimately needed some help. Well, it happened to be my cousin's neighbor. And this has been a client that has been with me for 20 years. We've wound up registering their trademarks all over the world, lots of trademarks, some design patents, other things in the US, and for shoe designs. And they make women's shoes. The cookies in my browsers are all jacked up because sometimes you have to look at these things. And so you're getting these little ad pop-ups and it's a very fashion forward company. So some of these products are pretty zany, so, things like that. It's almost anything. Every company has IP, whether they know it or not.
Sure. And then the question is, how do they protect it?
Yeah. How do they find out what it is? How do they find out what to protect? Because it doesn't always make sense to protect every little thing. It can get expensive. And so when I'm working with any company, but certainly with startups and small businesses, you want to be very mindful of cost and not just, going with a shotgun approach, but being really strategic about the items you are protecting. And a lot of companies want to protect logos right out of the gate. And I say, look, companies change logos a lot. Let's let that logo, use it for a while. And if after 2 or 3 years, you're really convinced that this is going to be your logo for a long time, then we can file on it, because you do develop common law trademark rights as well. So they're not as robust as federally registered rights, but they exist and they're enforceable. So almost anything really. And, artists too. I love IP because you're dealing with passionate entrepreneurs. You're dealing with creative, inventive people. And, one of the other reasons that science lost some of its appeal to me when I was in graduate school is because you're working in this little sliver of a larger system. And you have to repeat your experiments over and over to demonstrate that you have reproducible results. And you're doing these finite incremental things, testing things, and it gets really tedious. I wouldn't say it got boring, but it was just, there wasn't a lot of variation. And I was passionate about it and I was really into it. But with law, and as you guys know, as litigators and business attorneys, when you get different kinds of cases in, different issues, different subject matter, it keeps it fresh. Sure. It keeps your passion alive. And that's really what we get in IP is like almost everyone coming in the door got something different. So that's why I really love it. I tell anyone who will listen, it's the best area of law to practice.
So Mark, we always ask guests, because we're fortunate enough to bring in people who've enjoyed great success in their professional lives. And we like to try to help others out there who are thinking about, they may have an interest in this. So what would you tell somebody, a high schooler, a college student who thinks that they might want to get into intellectual property law? Like, what should they be doing? What should they be concerned about? What should they consider?
Well, one of the things that I think is super important, even at a college or post-college level, is, have a LinkedIn account and connect with people who do things that you're interested in and read what they post. Even areas it might not be specifically your wheelhouse. You can learn about economics. You can learn about healthcare stuff or employment law or whatever. So read broadly, but at the same time, if you're an undergrad, you're maybe looking to go into grad school or something, and it's take classes that are going to, acquaint you with the subject matter. take a branding class, take an entrepreneurship class as an undergrad. If you're a business major or something like that, if you're going to go to law school and you're thinking about IP, take an IP survey class. Or if they don't have something like that, maybe just dip your toe in the water of trademark law and see how you feel about it. And, our local law schools here are, and I assume most law schools everywhere are pretty connected to the local practitioners and helping people find clerkships. We do on-campus interviews, and we have a brand new, just took the bar exam attorney joining us, and she wants to do intellectual property law. And I was talking to her yesterday. I said, "Did you take any patent law classes in law school?" "Oh yeah, patent litigation and patent prosecution." I'm like, "Yes, you know something," and people at our level, 25 years in now, it's our job to train that next generation. And so, show them the right way from the get-go and hopefully enhance their passion. But certainly looking at course offerings, even for young lawyers, I tell them, you have CLE requirements, continuing legal education requirements, 15 hours a year in Texas. Are you going to go do a CLE in an area you're completely uninterested in just to check the box? Or go find a CLE program in intellectual property law or business litigation or whatever it is that's going to serve you well and enhance your competency as a lawyer. But also, for things like IP, the law is always changing. Absolutely. And so to stay on top of it and just stay in love with it, that's what I tell people to do.
So is there anything that we didn't ask you that you'd like to address?
Well, I've been pretty long-winded. Probably not. I mean, you guys I know are, great business litigators, and I'm not a business litigator. I steer clear of that. I hope there's a day that comes when we can co-counsel.
Oh, that'd be great.
You guys, I know you're admitted in a number of jurisdictions. What about you?
Yeah, Arkansas and Florida and Texas.
Yeah. So there may be opportunities. I'd rather work with someone I know than a complete stranger as local counsel. So
it's big. I think normally he wouldn't want to associate with me, but
oh well, in our networking meetings, there's usually arrows going back and forth across the table. But it is a sign of love, folks. So it's a sign of love.
Well, Mark, we greatly appreciate you by today, and thank you.
I super appreciate you guys having me. That was fun.
You bet. I enjoyed it.